Welcome back. This is our third installment of Startup Law for Founders. So far, Francesco, we have covered some of the basics of incorporation, where to incorporate, how, when. Um, in our last installment, we talked a little bit about the co-founder relationship and some of the things to think about as you approach that perspective, understanding. And today we're going to talk about onboarding a team, providing the opportunity to bring other people into the endeavor, into the vision. And I think, kind of to start things off, these are some of the first tangible things that you do as a founder, as an entrepreneur, to hit on some of these things we talked about at the outset: pooling resources, pooling talent, to make something that you can't necessarily do by yourself. So this really is like a pretty exciting moment for a company when they're starting to think about these things.
It is, and it changes everything when you got a team around you driving the vision forward. And one of the unique things I think about startups is the power of equity compensation um, and giving a group of people the opportunity to participate in this creation of value and this upside potential. And the successful founders that we've worked with have really understood that and used it to build teams of supporters and service providers and advisors that have been integral, I would say, to the early stages of success of the company, in terms of like getting work done, driving projects forward, but also introductions, opening doors. All of that can really make a difference. And I think that while you have to be sort of judicious and prudent and careful in terms of giving out equity and building out a team, and not building up a burn rate too rapidly. It's also, I think, there's also a risk uh, of holding back on that, and keeping everything too close to the chest, and then you can really hold your company back in that way as well.
That's interesting. Yeah, a lot of potential, a lot of excitement around this, but having that balance as you are making some of these decisions and negotiating with your first advisors, your first employees, et cetera, is really critical.
Yeah, no, absolutely. And like as startup lawyers, what we want to do is there's a few things that we want to do that really facilitate the process of onboarding team members, so that it accomplishes a couple of basic things. I mean, one is that it should be a relatively seamless and painless process. It should be standard in terms of the legal forms that are being used, um, and the documents that are being signed in connection with that process. But it also should be kind of robust and complete enough that it protects the company against what we see are the recurring, kind of things that come up, problems that come up, issues that come up in these service provider relationships. So that's the real focus of this module in the startup law for founders.
Yeah, let's jump into some of those. So, what are the main pitfalls that you see in your experience, having worked with so many entrepreneurs over the years?
Yeah, so in thinking about this, really boiled it down to four major buckets of issues that are we think are I think are just kind of recurring. They're mistakes that I see happen over again that can kind of create problems, complications, and sometimes major ones down the road. So one bucket is um, early stage founders may not be familiar with what is like market based compensation. So what is a fair deal, especially when it comes to equity? How much should I give this person? Is it a good deal? Is it fair? Is it appropriate? And in early stage companies, it's not like there's an abundance of data out there. Many don't have a lot of experience with hiring and issuing incentive comp, and so they may not know what are the terms to negotiate, how to frame the terms, and so forth. So, cutting a good deal for the company and ensuring that the deal has appropriate protections, that the company is getting value in exchange for what it's paying. That's one thing that we see regularly. The second thing is a lack of clarity in the engagement. So it's not that uncommon that we see people that have been kind of working together with no agreement in place, or maybe just like a general or vague understanding in place that doesn't have specifics around it, but that leaves open a lot of room for interpretation. And these are kind of suboptimal for a lot of reasons. Like I think that until you have like a real meeting of the mind and clarity, there's the ambiguous state I think affects performance, and it doesn't. In other words, like when you have a clear deal and everyone's rowing in the same direction, there's a momentum that can happen in that way. And whereas before, when there's an ambiguous state of affairs, that you don't get that same performance. The other thing is obviously ambiguity creates the potential for bad feelings to come up, and disputes, and partly with varying levels of harshness that create varying levels of distraction. When it turns out that people had very different ideas of what is fair and what what the terms of the deal was, and when we see that on a regular basis, and and it's not ideal. The third bucket is like where the ownership of intellectual property is not properly negotiated and documented, and this can create issues down the road, particularly in IP intensive companies where the ownership of the intellectual property is a big deal to not only to the kind of economic and financial condition of the company, but also in due diligence with investors, having clean chain of title to the patent, and not having a cloud on the ownership of the IP is a big deal. So getting that buttoned up in all of the service providers' relationships is real important. And then finally, there's just a compliance standpoint where when it comes to service providers, you're dealing with some pretty some pretty intense background laws, like employment laws, particularly in California. There's a lot of kind of traps for the unwary, and so you got to be sort of mindful of those issues, and make sure you're not stepping on unintentional landmines. And likewise with equity compensation, all like stock options and restricted stock grants, that's all regulated by securities laws, federal and state. And as well, there's a tax dimension to it. It's all taxable income, and so kind of the combination of those factors really means that you need just some basic legal guidance, and none of this is like to a startup lawyer. None of it is rocket science, and obviously it's just done in every single company, and it's very much standardized in terms of the issues that come up. It's kind of unique in every individual situation, but so I guess what I'm saying is from a startup law standpoint, we're not reinventing the wheel every time, but every single company needs to be looking out at the same compliance issues and making sure that making sure that when a team's onboarded, it's done so in a way that's mitigating risks, and not creating more problems down the road.
With all of these things, certainly a lot of companies are started, in the proverbial garage. They are, entrepreneurs are drawing on friends and family members to help out with a lot of initial concepting or work. At what point do you think it makes sense for somebody to start to get some help with some of these things, to talk to a lawyer about getting forms in place so that things are documented, or talking about what makes sense in terms of some of these market rate terms around equity and other things like that.
Frankly, I honestly, the sooner the better. I think that a lot of the biggest mistakes are made at the very earliest stages. So I think that a founder that is serious about pursuing an idea uh, and developing it, once there's at least some level of commitment to doing it, it would be real helpful to have a experienced startup lawyer at the very early stages, to be running things, by uh, and at least at the gut check level. And my feeling is that when you have that really every service provider relationship, anybody that's contributing to the company, from day one, it should be documented. It should be an arrangement that's in writing, that provides certain clarity, and that's kind of like what we'll get to next. Which is how do we address those four categories of kind of risks and mistakes?
It sounds like, once we talked about this in the first video, the time to incorporate is when you have that commitment to say, yes, I'm going to put energy behind this. Sounds like that's also the right time to say, I'm going to put energy behind this, and I'm going to make sure that I do it right, that I document things, that I'm making sure that the terms are fair.
Yeah, definitely. I strongly believe that. It's a professional endeavor, and even if you're working with friends, family, it is really beneficial, uh, not only from a business standpoint, but I think from the overall relationship standpoint. To be clear about this aspect of the relationship. So this is a professional undertaking, and here's what you're getting, and here's what you're giving, um, and and it's spelled out. So there's no, often it's the ambiguity that can result in hard feelings and misaligned expectations and so forth. Yeah. So yeah, I agree with what you're saying.
What benefit do you see down the line once the team is built? They've maybe got a product in the market, having this kind of clarity early on.
Yeah, the biggest problems that I see have to do with, one of them is that what the service, the founder wants to let somebody go. They want to fire someone. It's not working out. They're getting too much equity, and they're not kind of carrying their weight. And when you have good legal documents in place, that's a fairly straightforward process. The contract will say, here's how you do it. You pull the trigger, and so the whole thing is laid out. If you are terminated, so our standard agreements will basically say that this is an at-will relationship and it can be terminated by either side. You send a notice of termination. The equity is on a vesting schedule, and so there's you don't need the other party's consent. You can just move forward, and there's tremendous value in that. Likewise, in a documented relationship, there won't be any intellectual property problems or implications, because if you're using good service provider forms, all the work product and intellectual property will already be vested in the company, and they'll contain provisions protecting the company in terms of intellectual property. So we see situations where service providers have been, kind of collaborating with the founder without documentation and just on a kind of, informal arrangement, and then all of a sudden the relationship falls apart, and there's bitterness and acrimony, and there's no agreement in place, and we don't know how much equity this person is entitled to, or if they contributed to the intellectual property and need to be on patent applications and things like that. And that can create real stress and put a legal cloud on the company in terms of potential disputes down the road. So having documentation in place, avoids all of that.
The one thing I think I've seen a lot of, especially over the last few years, is the use of like a dev shop. So a founder or an entrepreneur is using developers often overseas, maybe they're in India, to
Yeah.
build out an MVP model of an app or some kind of product that they want to bring to market. Are there other considerations that you think they should be aware of when the engagement is something like that, where it's not necessarily an employee or someone that's close physically that's going to be working with you on the product?
Yeah, definitely. I mean, there's a number of considerations in those kinds of engagements where the accountability piece is a little trickier, right? So one of them is apart from the intellectual property piece, that's critically important, particularly with software development. Uh, you want to structure the engagement in a way that protects the downside. So I like advising. I like engagements that are structured in tiers or in phases, and that have a kind of a built-in accountability. So, for example, if it's $100,000 contract, not all of it is paid up front, of course, but you have, but the economic terms are such that there's accountability built in. So, once phase one is completed to our satisfaction, we'll give you X amount of money. Then phase two begins and we'll do a deposit for phase two. If there's equity comp, there's vesting associated with the successful completion of phases of the project. The other thing that's critically important is the ability to exit the deal if it's not working out. And so getting tied up in a deal, in an expensive deal with a service provider that is just not delivering is can be just an enormous resource suck. So we try to structure engagements where again, the ability to exit a deal provides a nice built-in accountability mechanism such that both sides need to be meeting their obligations and performing and satisfied with the arrangement in order for it to keep going to its completion.
One thing, and this is kind of looking forward to our next video about raising capital, but how closely do you think those things are linked? Onboarding a team, thinking about compensation, maybe even salary, and then thinking about bringing on investors and the capital you need to provide the compensation.
They're linked in a couple of different ways. I mean, one of them is that I think it's a part of the investor's evaluation process to examine, to see the team that's assembled and the quality of the team and the nature of the team and their skill level and so forth. So the team that is around the idea is a huge, I think, part of an investor's calculus in terms of whether to back a company. On the legal side, I think it's that if they're obviously there are major legal red flags. I don't know. It really depends on. It's hard to say. Like I think that if the opportunity is fantastic, I think that an investor might, yeah, might learn to live with it. On the other hand, uh, you know, in a tough, it's already hard enough to raise money, right? So having the legal ducks in a row is another kind of indicator that a founder is savvy, responsible, and understands, just running the business in an effective way.
Kind of what I'm hearing is, the investor is going to look at the normal financials, product market fit. They'll want to see traction, depending on kind of where the company is in its stage. But they're also going to want to see the right team, right composition of people, and also that the entrepreneur, the founder, has done their kind of due diligence with the team to make sure everything's buttoned up, they have the IP protections, that there's some standardization to kind of the formation that's happened with the team.
Yeah, definitely. I mean, the investors are looking, of course, at the upside, the market opportunity, and the team. Then their lawyers are going to look at the and do the due diligence folder, and will tell their clients like, here's the story there, and ideally, the story will be no story at all. It's just everything is in order. And if it's not in order, then the lawyer is going to tell their client these are the risks, these are the potential problems, and then the investor is going to have to determine if they're okay with it, and if they're comfortable living with it. So um, we want our clients to have a clean bill of health. No, it's valuable for its own sake, because without it, it does create complications, expense, costs, and headaches down the road. We see it over and over and over again. Uh, but then this other due diligence piece is sort of is another good reason to do it.
Yeah. The sense of clarity is really an investment in your long-term health, the long-term health of the company and of the idea, so that it has a chance to really flourish from this kind of seed stage to something that can make a difference in the market.
Yeah, absolutely. It does. It really makes a difference.
Cool. Um, and with that little teaser, our next week is going to be talking a little bit more about capital raising, preparing your company for that process.
Exactly.
Cool. Thanks so much, Francesco.
All right, Chris. Good talking to you.